want to welcome everybody to this webinar this afternoon from different jurisdictions. Wish you good morning, good afternoon, good evening. And we're looking at the title, The Singapore Convention on Mediation, Enforcement and Other Issues. And we have quite a distinguished panel of speakers here today to give us their perspective on the issues from their different jurisdiction. I'll do the introductions and then I'll call on my friend Samir to moderate and take the questions. Just to give a background, the United Nations Model Law on International Commercial Conciliation 2004 was revised in December 2018, and on the 7th of August 2019, 46 states signed this convention called the Singapore Convention, and there were 24 states that witnessed but did not sign yet. Thereafter, the uptake has gone up to about 52 of 53 states as a state. On February 2020, Singapore passed the Singapore Convention as the Singapore Convention on Mediation Act 2020, and on 25th February, Singapore and Fiji deposited their instruments of ratification with the United Nations in New York. And on 12th of March, Qatar also deposited their instrument of ratification, and Saudi Arabia has also done so. So we have the convention coming into force on the 12th of September 2020. And it's basically to create a uniform and efficient framework for international settlement agreement arising from mediation. So as this agreement comes into force, we're going to look at enforcement and other issues arising from the convention coming into force. So we have distinguished panelists. We have Tony Nguyen from Vietnam. Tony is the founding partner of EP Legal. He's one of the top-tiered lawyers in project and energy law in Vietnam, highly rated by Chambers Legal 500, Asia Law, and other publications. Tony has 19 years experience in the project and energy industry prior to starting EP Legal in 2010. He's worked in oil and gas projects, both drilling and contracting, and is a dispute resolution counselor in litigation and ADR in Vietnam, Singapore, Hong Kong, and has represented clients in the Vietnam International Arbitration Center and the Singapore International Arbitration Center. He was the first mediator and Vietnamese member certified by the CAAB in Vietnam, and is an arbitrator of the Vietnam International Arbitration Center, and recently was appointed Deputy Director of the Vietnam Mediation Center. He helped to draft the Code of Ethics for the center and trained mediators. We also have with us today Ambassador Manahem Chok Kanafi. He's a retired diplomat and advocate of the Supreme Court of New York and Israel. He was the first Consul General of Israel in Bengaluru, responsible for forging relationships between Israel and South India, especially in the field of high tech. He's a key negotiator with over $1 billion experience and decades of international trade experience, especially in high tech dispute resolution. He has special emphasis on cross-cultural conflict involving Israel, India, and the United States of America. He has a mediation success rate of 87%. I guess you want to appoint him as a mediator. We have also Samir Sher, who will be moderating the event today, an advocate, arbitrator, and mediator. He's the director of the Chartered Institute of Arbitrators India branch. Is a council member of the Alliance for Equality in Dispute Resolution. He's a panel arbitrator of the Court of Arbitration for Art, Netherlands. He is a mediator and ambassador, Mainland Hong Kong Joint Mediation Center in Hong Kong, the Mediation Center in Dubai, and is the principal of SU Shah and Associates. He'll be moderating the webinar today. We also have our esteemed dispute resolver, Anil Shangaroth, is an accredited mediator with the Singapore Mediation Center, Singapore Family Justice Court, Asian International Arbitration Center, Vietnam International Mediation Center, and the International Dispute Resolution Risk Management Institute. He's an arbitrator, the fellow of the Chartered Institute of Arbitrators, Singapore and Philippines, the practicing adjudicator in international treaty arbitration, and is also a dispute avoidance and resolution practitioner. I will also be one of the panelists today. My profile is very brief, more on LinkedIn. Principal partner of Brilliant Associate. I'm an arbitrator, accredited mediator and conciliator, and I am also a member of the African Arbitration Association, the Chartered Institute of Arbitrators, the Institute of Chartered Mediators and Conciliators, the Institute of Management Consultants, and the Nigerian Conflict Management Group. I'm also a fellow of the Society of Advanced Legal Studies of the University of London. I'm on a panel of different arbitration and mediation institutes, and also a member of the ICC Roundtable in Nigeria. So, having done introductions, I'll go over to Samir and have him start the webinar straight away.
Thank you, Eddie May, and I'm really thankful for organizing this webinar on a very interesting topic, because it will be just under 2 months when the convention will come into effect. And as you just mentioned, 7th August 2019 was a historical day for the world mediation community as such, when this convention was signed. And however, we have seen just 4 countries who have ratified so far, though there were more than 40 countries who have signed. So there is a need to understand why or what are the reasons that's stopping the signatory countries probably from ratifying it, or are there any inherent issues inbuilt in the convention or in the drafting itself, which needs to be discussed once again probably, and maybe rectified to a certain extent, or maybe added something to be added. So all these issues is what is the topic today, and we'll try to go through this journey through some questions which we have prepared to be answered by distinguished panelists today from different jurisdictions, to understand what are the basic problems or issues of convention not getting that much of a response as it was expected. So without further delay, I just start with Anil on very first question, and that is, do you actually think, Anil, as there is a need of a proper legislation on mediation which is required before this convention can actually be implemented? I think you have to unmute, Anil.
Sorry, my take is yes. We should have a legislation. Let me explain why. If you take a look at the convention itself, right? Article 11 of the convention says that a state becoming a party to the UN convention or protocol, right, requires its signing and ratification either by way of an instrument or acceding to them. And you have ratification, you have acceptance, you have an approval, right? So what does these elements involve? First of all, you have the signing. So on the 7th of August is when we had the signing, right? So everybody knows that there were 46 countries that signed, and there were 6 other countries that signed on later on, right? Eddie Aitney had correctly pointed out that only 3 countries or 4 countries have so far ratified it and submitted them. So it's a process that you need to go through. If you pull up anything on United Nations convention, you would see that the conventions in the United Nations require these steps: the signing, the consent, the ratification, and possibly the ascending to the convention. So it's not just a case of parties just signing off. They really need to go into and take further steps. Now, along with that, you have to consider whether different countries have different approaches of doing it. In some common law systems and civil law systems are slightly different. In common law systems, you may have the parliament that makes decisions and pass acts that put in place a framework for it. Again, Adimi had correctly pointed out, in February this year, the Singapore Convention on Mediation Act 2020 was passed in Singapore. So that effectively ratifies the convention, and it sets out some guidelines in the act itself, which I'll talk about in further questions that we deal with. But essentially what it does is that you have an act that has got provisions, and annexed to it is the convention. So once it's ratified here, it then needs to be submitted into to the United Nations, and that's where the steps and process takes. So my take is that you'll need legislation in place to crystallize the convention that parties have signed into.
Thank you, Anil. That actually clarifies the to a certain extent the position of Singapore, and I think Singapore always has been a leader so far as many ADR processes and proceedings are concerned and laws are concerned. Tony, if you can also throw some light on this question so far as Vietnam is concerned.
Yeah, thank you, Samir, and also thank you, Anil, for sharing the information on Singapore. I think Vietnam is not yet a member of the Singapore Convention. This is a pity for us. I actually attended the signing ceremony of the Singapore last year, and it was very exciting, but we were not part of that. I think the main reason why we are quite skeptical about having admitted to the convention is that we need some time to get used to it. It is too new to us. In countries, for example, India, I understand that 2 weeks before the signing date, India was still not having the plan to be part of it. So same as Vietnam, and we are not as quick as India. So we can say that we are lag behind in this process. But sometimes being skeptical and scrutinize the situation is important. And for Vietnam, it is about the comparison of the local system, the legal framework of Vietnam, before we fully assess the impact of the convention to our system. Then we can say yes very easily to the convention. And I think the main legislation in Vietnam, the main piece of regulation in Vietnam at the moment is Decree 22 in 2017. And also the Civil Procedure Code. But it has some difference in practical application compared to the Singapore Convention. In another event, I already made very detailed analysis of it. But due to time constraint, we are not going into details. But obviously, one of the main reasons why we are still not in the pool of these 52 countries is because we are assessing and we are trying to do our own research, do our homework to see what will happen if we are a member. And of course, we want to take no observation or as least reservation as possible for admitting to the convention. But it is important that the local law need to be assessed, and if we admit to the convention, there must be some changes in the law to give effect to the admission of Vietnam to the CAC, to the convention.
Well, thank you, Tony. I mean, you're right in a way that about Indian position before signing, and we were also quite skeptical whether we would be a signatory or not. But fortunately, we did sign the convention. And just to add to from the Indian perspective on this, currently India actually is also working on coming out with a mediation act, and probably that will also give a good support for implementation and enforcement of the convention as such. But we need to see what happens, because it's a very, very early stage even for India. We don't have any mediation act for that matter. And we just have recently in 2018, there was an amendment in the Commercial Courts Act, in which the pre-institution of pre-litigation and mediation rules were inserted. So therefore, now any commercial dispute doesn't go to court first. It has to be mandatorily mediated, at least for 3 months. So that's the only position right now so far as India on mediation is concerned, though it is picking up very well as in a practice as such. But under the law, this is a position so far as India is concerned. So I just also ask Ediemi about the position in Nigeria.
Well, in Nigeria, it's pretty much the same as in other jurisdictions. There's no clear mediation legislation yet. However, we have the amendments going on to the Arbitration Act, and there are far plans ahead to also incorporate the mediation and conciliation rules and provisions within that act. By and large, mediation is practiced more through the rules of the courts, through the civil justice system. So we have mandatory provisions for compulsory mediation in most of the states in Nigeria, and the Federal High Court recently has opened also a mediation center. We have the Court of Appeal Mediation Center and Supreme Court Mediation Center, even though the uptake is not what it should be, but it's becoming the norm now to have compulsory mediation before parties proceed to have their cases and listened to by the courts.
All right. Thank you so much. I think, Chuck, your views on this?
Thank you, Samir. I think first off, it's a fairly good idea that the Singapore Convention has been signed before states have adopted a mediation act or a mediation law, because then it can be harmonized from the very beginning. I'm sitting here in Berlin, although I'm representing the Israeli system, and as I assume everybody is aware, the European Union did not sign on to the Singapore Convention because there is a European mediation law, and there would have to be some sort of harmonization done in order for the states to sign on, which would be an incredible boost. Of course, it's another 29 countries which would join overnight if that were to happen. I don't know if necessarily there's a need for special legislation. It depends on what's there in the system. Of course, under international law, we know that if a country signs a treaty and then ratifies the treaty, they're under a moral, if not a legal, obligation to give that treaty with force within their own domestic law. So hopefully we'll see that, and I know that in Israel, at the very least, the Ministry of Justice is examining the provisions of the convention vis-a-vis the law and the civil procedure regulations to see if there's any need of harmonization, which would happen, of course, as a second step. I think it's possible today that that there might be a bit of a conflict between, let's say, bilateral treaties for the enforcement of contracts. At the end of the day, a mediation settlement is a contract. There might be some sort of clash there that would have to be rectified. And that would be difficult in common law countries, of course, because enforcement of judgments is often a matter for precedent rather than for statute. At least from our point of view, I don't think there would be a lot of difficulty, and I would think that that would be the case in a lot of jurisdictions. It would be possible to begin implementation of the convention even before full mediation acts would be implemented.
Well, thank you, Chuck. So we think, I mean, we have equally balanced views but in nutshell, I think what the panelists feel and that there at least need to be some regulation required to have a proper implementation and enforcement of the convention to be adopted by respective signatory countries. Let's take me to another important question about which is more has been debated in arbitration, but it is to an extent now equally important in mediation once the Singapore Convention coming into play, and that is the issue regarding a seat. So what do you think, if I just pose this question to Adeyemi, do you think there is any requirement of a seat in mediation?
Well, obviously, the concept of the seat or the localization theory come from arbitration, where the 1958 New York Convention looks at the issue of recognition of foreign awards and define what foreign awards are. But when we come to the Singapore Convention, we're looking at international settlement agreements arising from mediation. So obviously, it has sidestepped the issue of foreign or nationality of the settlement, primarily because the mediation is of a contractual nature. And while the arbitrator replaces the state judge and acts legally or in a judicial capacity, the mediator, on the other hand, merely helps parties facilitate discussions towards an agreement. So the convention obviously has not mentioned any seat, very much like the Convention on the International Sale of Goods, the CIFG, on the UNIDROIT principle of international commercial contracts. It merely in Article 1 defines the nature of the international requirements for the parties, and also states clearly that you can tie in the agreement to any seat is unimportant. However, it must be recognized in the context of the law of the jurisdiction in which it is coming to be enforced. So the emphasis is not really on the seat of the mediation, which probably doesn't exist, or like I've tried to argue, should it exist? I have an article on that, but it's more important on the jurisdiction of enforcement. And Article 5, subsection 1b talks quite a lot about that. So it's quite a balancing act. While arbitration holds nationality of the award, primarily because of the issues of recognition, the enforcement basically of the settlement is more given a more free regime.
Well, thank you for those views. And if I may ask, Anil, your take on this.
Yeah. Okay. So my take is exactly Adeyemi had said it quite clearly, succinctly. You start off with first of all looking at what seat is about, and in most of us who are arbitrators and who deal in arbitration matters would know that you are talking about a legal concept, not a geographical location, and it refers. Seat refers to a legal. It has got legal significance, and it determines the applicable law in carrying out the arbitration, the process of carrying out the arbitration, and so on and so forth. So that's what a seat is. But if you take a look at mediation, mediation is basically two parties coming together and coming to an agreement that they are comfortable with. They're guided by the mediator, but it's both the parties coming to a decision and coming to an agreement at the end of the day. So really, if you then take it to issues about enforcement, right, there shouldn't be a question that there does not need to be a question on how was the process done, where was it heard, how was it dealt with, because it's just an agreement between two parties across the world, across nations. So this point about seat, in my take, should not come into play insofar as mediation is concerned. And in fact, the UNCITRAL Working Group 2 that dealt with arbitration, conciliation, and dispute settlement, right, actually reviewed this carefully and considered whether this point about seat was necessary, a point to be considered, right? But they decided that, in part to avoid giving legal importance to one jurisdiction as opposed to another. And so they decided that it was not necessary to keep this as an element that's necessary in mediation. So that's my take on that.
All right. Thank you, Anil. So I think very rightly pointed out that seat is basically not that an important requirement. So while mediation is concerned, that takes us to another important issue of which is more important, I would suggest, in my view, than arbitration, and that's confidentiality. And when we are talking of confidentiality, and we are also today talking of enforcement, so if we speak in a general way, there seems to be a little contradiction between the two. So if I may ask Tony, Tony, do you think that, enforcement, when we are talking enforcement under the convention, it may breach confidentiality as such?
Thank you. I think that's not only applicable to mediation, but it's also applicable to arbitration that we usually have problem with in Vietnam. When we try to enforce an arbitral award, we usually have to face a problem that the award will be shown up. In the UK, for example, usually there's a way to for the court to redact and to delete the sensitive information before it is open to the public to see. But in Vietnam, we do not see that. And for mediation, for mediated settlement agreement, I think the same issue could be the question for the courts, how the courts will see the mediated settlement agreement in terms of keeping the content of the agreement away from the public because it's confidential between the private parties. I don't find any solution for this, but I think if the proceedings in the court could provide that the general information of the agreement is provided, and the names of the parties and even the name of the mediators could be deleted or renamed to be anonymous, then it could be a good way to keep the confidentiality in the public hearing for assessment of the enforcement of these mediated settlement agreements.
Yes, but you see, what we are talking here of a mediated settlement agreement, and the question, according in my mind, is whether you actually need any enforcement, because we are talking of a mediated settlement agreement where both the parties voluntarily have signed the agreement. So the issue is, if there is no need of enforcement as such, then where's the question of breach of confidentiality as such? So Chuck, what are your views on this?
Okay, I'd like to take a slightly nuanced view to that. I mean, first of all, in the experience here, confidentiality is one of the #1 reasons to go to mediation in the first place. That's alongside speed and whatever, especially if you're talking about in high tech and intellectual property. Nobody wants to go into open court. because they may not have patents yet, and the moment they go into court, it's public knowledge. So the issue of confidentiality is key in attracting a certain type of case to mediation. There's always in a lot of jurisdictions the possibility, for example, of submitting the mediation agreement for a consent order in the court to give it the force of a verdict, and we see that in the vast majority of cases that's not done. That's not done because nobody wants this agreement to be in open court. I also agree, Samir, with what you were saying about it being a settlement agreement, which is done by consent of the parties. In fact, if you come to a situation of enforcement, you're actually talking about a failed mediation. Because the mediation should have been with full consent of all the parties involved, and in that case, enforcement shouldn't be necessary. In the statistics, I think we see that too. That in a lot of cases, mediated settlements are the obligations of the parties are fulfilled without resort to adjudication in a much higher percentage than adjudicated awards, be it arbitration or be it court proceedings. So in my opinion, first of all, I agree that it shouldn't come to enforcement in any case. And of course, we see the word enforcement only actually appears 1.5 times in the convention. And the second thing being that submitting or the possibility of submitting an agreement for enforcement would be a serious blow to confidentiality, and therefore a serious blow to the attractivity of the process.
All right, thank you, Chuck. Anil, what are your views on this?
Let me just take, Samir, your first point about, it's a mediated settlement and why do you need enforcement? That's something I thought of quite some time, when the euphoria of the convention coming up, right? Everybody was up in an excited state. Oh, we've got this convention coming up and all that. And I just look back at the fundamentals of mediation. It's a settlement that parties come to that they agree and they are comfortable with. Why are you ever going to talk about enforcement? There's no necessity for that. But truth be told, I read a very interesting article, and then I spoke to some people internationally, and I realized that the culture of mediation in various countries are very different. There are people or countries and parties that go into a mediation just so they can avoid going to court or arbitration, come to a settlement that they never intend to fulfill in any event. So there are places and countries and cultures that have that. So I suppose to some extent, the convention kind of gives them that framework of some concreteness. Another point is also this: people in some places say that mediation is not binding, it's informal, and so on and so forth. That too, I can't really understand, because at the end of the day, you just sign an agreement, and once you sign an agreement, if it's a construction matter that's got 2,000, 3,000 documentations, all of the documentation goes out the window. You just look at the agreement. That's it. All right, so that's Samir's point. Chuck's point and the other points about the confidentiality. Tony's point about confidentiality. This is what I want to say. Two things. If you look at Article 9 of the Singapore Convention, it spells out the conditions and confidentiality aspects. It tells you when the mediator can reveal information to the parties. Article 10 goes on further to talk about unless the parties agree, information are kept confidential. So this convention gives you that sound footing of some form of confidentiality. Interestingly, if you take a look at the Singapore Convention on Mediation Act, right, it's got a whole lot of sections, and the sections tell you, for example, Section 4 of the Singapore Act sets out the details of how to apply to the High Court to record the agreement, what you must do. And Section 5 talks about how the High Court would grant leave to record the settlement. Now, in Singapore, you must understand one thing. When we do arbitration matters go to court, all of them are redacted. The parties' names are not named. And so when the case report comes out, it comes out AB against CD and so on and so forth. Right? So when you go to look at the case reported, you know that they are all kept confidential. So because of the Singapore Convention on Mediation Act 2020, sets out this framework of how you can apply to court and how the court can give leave to enforce and so on and so forth. I think that mechanism itself would keep the parties' names and certain other details confidential. So, you know, you want to think about whether or not you want to pass that kind of legislation to make sure that when you're taking steps for enforcement, even then there are securities in place insofar as confidentiality is concerned. All right?
All right. Thank you. I mean, that takes me to the next question, just taking a cue from what you just said, Anil, about the mediated settlement agreement. Now, here we are talking of an agreement, so which, according to me, means that something more is required to be, still required to be performed, you know, for that agreement to actually come into play. We are not talking here as an award. We are not talking as it is as a sort of court judgment. We are saying a settlement agreement. So this, according to me, also this seems a little bit of discomfort and issue here, that we are talking of an agreement which is yet to be. So there is something more to be performed. So there is nothing. So there is a discrepancy between what we say settlement and then we say an agreement. So the question is there a finality when you're talking of the mediation settlement agreement? And because it is not as accepted or enforced as readily as an award or a court judgment. So why we are talking of a settlement? Why can't we just simply say a mediated settlement and just stop at that? Why we are adding a word agreement, which to an extent means that something is still required to be performed? Anil.
Oh. Okay, I never split it. I never split it down that way along the lines of a settlement agreement. You know, I don't know whether or not they're just covering all the bases by saying mediated settlement agreement. Therefore, it's so clear that you have agreed, you have settled, and it's party's decision, right? So I would think that the level of finality is in the settlement agreement itself. Sorry, I'm going to join the two words. The finality comes from that. It's very, I think personally, I think it's very different from every other agreement there is. With every other agreement, most parties never look at dispute resolution mechanisms in the agreement because they say they'll never have disputes. But you know, the first thing that happens in all agreements is a dispute. You know, there's the old saying that contracts are made to be broken, you know, there's always an exception and so on and so forth. But here, in a mediated settlement agreement, I think it's far more crystal clear that we are coming into it collaboratively, working together, coming to an agreement that we are both comfortable with. So there's really no avenue for us to fall apart or give it up and break apart and then go forward. So I don't think you need these things like award or an adjudication determination or adjudication decision, a dispute board decision, and so on and so forth, because this is something that the parties have gone without any influence from any third party and come to a decision. Now, this part about this influence of third party, I'd just like to highlight just one quick thing about mediation. You know, there are some institutions and regimes that will say that, you know, we've got the best mediators on board. We've got the industry experts and front leaders leading the mediation as mediators. You know, can you imagine if you are a bunch of contractors getting into a mediation and you come across and you're faced with a mediator who's an industry leader, right? Now, is it going to be a pure mediation where I get to decide with the other party? Or am I going to be influenced by this mediator such to the point that if a mediator says, so would you like to think about that? Then I think, oh, if I don't think about that and I don't accept the mediator's guidance on this, you know, 6 months down the road when I pitch for another job, that same mediator might be in the place and look badly on me. So, you know, this concept of mediation and how settlements are arrived, you know, you really have to go back to the fundamentals of it. Did you really have a person who's neutral and just guiding you all with no influences? You know, like for example, if you talk about court annex mediation, there might be some level of evaluativeness as opposed to just facilitative mediation. So I know I'm deviating a little bit, but these things all come into play coming to that mediated settlement agreement, right? So some of the problems that you may have to consider. it might be a question that comes up in a while too as well.
Yep. So Yemi, what are your views on this?
Yeah, I perfectly agree that with Anil, that if you have to enforce a mediated settlement agreement, then obviously mediation has failed. One of the things that I find with the rise of court-annexed mediation is that we have what I call muscle mediation. You know, the mediator feels I have the court behind me, I'm representing the judge, and so if you don't take full value of this process, you will end up in court and the judge will look badly on both parties. So we tend to have parties being silently coerced to accept settlements which they don't intend to perform. And even though the convention here on international mediation talks about the independence and impartiality of the mediator, I've written articles asking, can you really be independent and impartial in a matter that is before you? So just like Anil said, you find out that you want to start out facilitative, but eventually when the parties have come to a stalemate, and in trying to break the stalemate and do some reality testing, you become quite evaluative. Do you know if you go back to court, this matter will spend 10 years? I think that's really blackmail. That's emotional blackmail. I wouldn't do that. So you find that you have muscle mediation, and of course, where muscle mediation takes place, the agreement is most likely to fail.
Mm-hmm. All right, thank you. I just take a cue from what Anil just mentioned about the mentality in different jurisdictions and about mediation settlement agreement. And, you know, many times it has been seen that, you know, parties just enter into just for sake of it, just to avoid the initial issues into that. So then let us also try to discuss about, in this context, what could be the probable reasons which can make a party, you know, derogate from the mediated settlement agreement. Tony, would you like to answer this?
Yeah, I think it depends on the pretty much on the culture, the business people in different countries. In Vietnam, I think one of the main reasons why, firstly, mediated settlement agreement is put in context compared to a normal agreement, is that people have the tendency not to comply with the contractual obligations. So they sign agreements, but they very naively, they don't think that they need to follow or to comply with the obligations that they already committed. For example, if one party see the change in the price of the market, he can easily just walk away from the contract. And in Vietnam, we have a particular issue of enforceability of the agreements. So we have to follow very slow and very long process, very painful process to or proceedings to obtain and enforce the right of the victims. So that's why when we talk about mediation, the first thing the parties will ask is that, is it enforceable? If mediation is not enforceable, I don't do mediation. So I completely agree with Anil. This is really a problem of mentality. So if I talk about this in another country, in some other seminars and workshops, when I talk about this, people just laugh at me and they say, we have an agreement, why we need the enforcement? But in Vietnam, we need it because there is a tendency that the parties, especially the parties without the use of legal counsels, if they don't have in-house counsel, and if they don't hire external lawyers, usually when they come to disputes, they don't believe that they have to comply with their obligations. They just explain that the market changed, the situation changed, and then they have to change their reaction, and that is a breach of the contract. So if we have, for example, the mediated settlement agreement under the Decree 22 and the Legal Procedure Code of Vietnam, we have the tool to enforce the parties when they get into settlement agreement, it will get a shorter and a quicker way to be enforced. If a party later turn out to, if a party later wanted to break the contract, the mediated settlement agreement is purely a contract, binding on both parties. But if it has an additional tool to give more security for the party who believe that it will not breach the contract, who believe that it is more likely to be a victim, then it will give a better context or environment for the parties to encourage themselves to have the mediated settlement agreements. And Ani was right. The mediated settlement agreement is different from the normal way of contracting in that it will be very simple, very clear-cut clauses, and the mediator will help the parties to make very clear and enforceable articles and provisions so that it can be enforced. And no party could later say that this is unclear and I cannot do it. It's very weird, and it's very unusual in mediated settlement agreement. But in normal context, complicated contract, we'll see a lot. The parties disputes because the unclear provisions in the contract, and we don't see that in mediated settlement agreement.
Well, thank you, Tony. Anil, would you like to add to this, what Tony said?
Just an interesting point, right? I was reading the Singapore Convention on Mediation Act 2020, right? And it's got a whole lot of sections that deals with, like, for example, Section 6 deals with the requirements for the application that you want to make to enforce it. There are certain requirements that you must fulfill. Section 7 talks about the grounds for refusal of the application to enforce. Section 8 then talks about how the order can be set aside. So my point is this, interestingly, this convention and the act that has come about may give people more avenues to challenge and fight against a mediated settlement. So chances are, you might see as a result, people who read the convention, read the act, will then sit around and say, okay, I've entered into this agreement. Now I don't want to comply with it. Let the party take me to court and then try enforcing. When you try enforcing, I've got all these sections in the act, I've got all these sections in the convention that I can challenge. And there, so as much as the convention and any acts that follow the convention puts in place a clear structure to enforce, it gives you that much more avenues of challenging it as well, right? So something to consider.
So that's exactly what leads me to the next question, that do you actually need those kind of grounds for challenging, as mentioned in the convention? Because if you see the Article 5, which lays down those such grounds, according to me, A, B, and C of subclause 1 are actually goes against the basic purpose for which the convention is made, or actually goes against the basic purpose of mediation as such. To an extent, D, E, and F are, to a certain extent, can be a ground for challenge. But we see if these kind of grounds are mentioned, already inserted in the convention, then it doesn't make any difference between an arbitration challenge or a mediation challenge. So, what do you think, Eddie, Amy, if I ask you about this?
Well, this is simply amazing. I agree with Anil. The sections that talk about incapacity, null and void, inoperable, not binding or final as to the terms. I think, yeah, maybe parties in good faith will watch out for those. But the sections that deal with serious breach on the part of the mediator, failure to disclose circumstances that will give justifiable doubt to impartiality and independence on the part of the mediator, and also the lack of clear understanding or interpretation of the terms. In incorporating these clauses into the agreement, I think it's going to be a field day for counsel to simply opt out of the agreement they've made. And the first thing that came to my mind was, as a mediator, if I don't have immunity, am I going to have to appear before a judge to explain my breaches? You know, it's it's scary.
So, Chuck, what do you have to say on this? What Yemi just mentioned about the grounds of challenging, especially the impartiality and all. I mean, what if that, in spite of there is a mediated settlement agreement been already entered into, and then can a party still go on these challenges on the grounds as mentioned in the convention?
There's two questions here: is can a party or should a party? And those are the two very, very different things. Can a party? It's quite possible. If you look at the Singapore Convention, it gives you, sometimes by adoption, but it gives you almost every contractual defense there is. If you get it in, not only that, it adds public policy. And we all know what a can of worms public policy is, right? So the convention gives you those things and may actually be giving you grounds for attacking the agreement that you wouldn't have even had if it were just a mediation, let's say, up until the convention or otherwise. But again, if the mediation is conducted, I don't want to say properly, and I don't want to attack my colleagues here, but the parties, one of the jobs of the mediator, aside from bringing about an agreement, is to judge or to measure the good faith of the parties. And as a mediator, if you see that one or both of the parties are not acting in good faith, you're allowed to say, okay, we're done. This is it. The mediation doesn't go onward. Of course, there are consequences for you as a mediator, but that's always a possibility. And I think we should always keep that in mind, especially in situations where you say, hey, counsel is just using this as a delay tactic, or counsel is doing this with no intent to perform, because again, at the end of the day, what you're winding up here with, according to the convention, is all of your standard contractual defenses, and that of course goes then to the question of finality as well, and then you've pretty much just come up with a litigated issue. You've just added another phase in, which really doesn't help anybody and which defeats the purpose of the mediation in the first place.
Mm-hmm. So yeah, Anil, you want to add to what Chuck just said? Can or should?
Yeah. So exactly, Ademi and Chuck have said correctly. Exactly. This Article 5 is crazy. I mean, to me, it's crazy. It has got 4 different elements. One element is it talks about the contract itself. The other element is the mediator's conduct. The third element is whether it's a subject matter is capable of settlement, and the last one is public policy. As Chuck as mentioned, right, going down the path of public policy is opening up a massive can of worms. So let's put that aside. Now let's talk about subject matter not capable of settlement by agreement. But parties got into that agreement. I mean, here in Singapore, we have mediated settlement, and in family matters, in some criminal matters, low-end criminal matters, also we have mediated settlement. So mediation, if you understand the fundamentals of mediation, I personally take it that any matter can be settled by mediation because it's between the two parties involved, right? So that takes up that element as well, right? And then you have the mediator's misconduct. I mean, why are we going down that path? Because if you're a true blue mediator, you'd never make mistakes, or you'd never cross lines, because it's just naturally not possible, because that's what mediation is about. It's for you to sit down there and, it's some people in Asia, we call it Tai Chi. That means, we listen to one party say something and then turn to the other party and say, so what do you think about that? Sometimes, it's like a psychologist, a psychiatrist interviewing the patient and saying, yes, I understand. So what do you think you were thinking about? And so on and so forth. So the part about mediator misconducting and all that shouldn't be an element, shouldn't be a part of it, because it can't happen. It's not like an arbitration where you could cross certain lines and falter on all of those kind of things, right? So that's my take on it.
All right, just a last quick discussion point, because we are really running short of time, but just to add to, just from a cue to what Anil and Chuck just said about the challenges part, do you think, those challenges are the real issues or can they become real issues in enforcement, or there's something more to issues to enforcement? How do you compromise? I mean, how do you understand that? What could be the further probable issues into enforcement apart from these challenging grounds? Anil, if you can lead the way to this.
My take is this. Again, it comes back to the fundamental: is a settlement agreement. Why would there be a problem? But now looking at the convention and the act in place, there might be avenues for people to raise some of those issues, either in the Singapore Act, that Section 4, 5, and 7 that provides how it can apply, cannot apply, and all of that, or the convention, Section 5, Article 5 of the convention. So I really think if your nature and your culture does not really embrace mediation, you're looking at issues and problems that people are going to use. A smart lawyer is going to pick up on all of these provisions and put out a list of all the faults that we can pick. You see, but if the culture of mediation is right, I don't think people would go down that path. That's my take.
Well, I think, you see, even if I talk from Indian perspective, I just mentioned about the Commercial Court Act where the litigation mediation rules have been inserted. We are still treating mediation, the finality as the agreement with an award. I mean, why do you want to, why don't we have an independent identity to what has been settled finally in mediation? I mean, you are still making it here similar to an arbitration award or a court's judgment as such. But so we need something more to, get it properly enforced if it is required, if enforcement is a requirement. So this is also an issue that we need to at least have some more weightage to be given to a mediated settlement agreement. What do you have to say?
Sorry, Samir, on that, just a quick point. I think it's also necessary for people to appreciate that there are two forms of dispute resolution. One is consensual and the other is adjudicative. The consensual is where parties, conciliation, negotiation, and mediation, where parties come to decision themselves. Whereas adjudicative is where a third party comes to the decision that one party will never be happy with. Finding fault with a consensual dispute resolution mechanism, that's a whole different ballgame. I don't know why anybody would want to go down the path of finding fault with that. So I think, again, it comes back to a cultural issue and how the culture of that country or the jurisdiction takes to mediation, I think.
Yeah, thank you, Anil. Adiyemi, you want to add to this?
Yeah, well, mediation is about emotions. Just like Anila said, it is true justice because it's not adjudicated, it's consensual. So when you have post-mediation ego issues, withdrawal syndromes, loss of faith, parties sometimes, if the mediation is not conducted properly, could go back and now derogate from what they've agreed on. So I think it still goes back to practitioners, not doing mediation properly, but ensuring that they facilitate proper discussions that look at all the issues, the interests, the needs of the parties, and get to the bottom of the matter, so that when this consensual decision is made, parties consciously, in good faith, want to hold on to it. Now, there could be issues like in Nigeria, you could enter an agreement with the bank, and the interest rate just leaps in overnight, and into double digits, or the exchange rate could just, take off in a new direction, and that could be genuine grounds, not to want to continue with an agreement you've entered into. But I think that when parties go into mediation, they need to understand that it's consensual, and if it's properly conducted, they should, in good faith, execute such agreements.
Chuck, you want to add your views on this?
Yeah, I'd just like to add that first, that as mediators, we have to look at this again in a fully consensual matter, and we can put whatever we want into the agreement. If we take a hint from family mediation, for example, you can put in a clause that says if there are differences of opinion which come up in terms of performance later on or whatever, we'll remediate it or we'll mediate something else. Now, that does injure finality, of course. And in business, we need finality, and that's why it's not really as common as it is in family mediation. But you can, in a mediated agreement, put in, an ADR clause. Just like in the original contract, and then say, if there's a problem, yeah, let's go back and let's talk about this again, and not run to the courts with it. I think that may be a little bit utopian. It may be a little bit utopian, but it would be if you have, again, a suspicion that the parties are thinking about the next step and thinking about how not to perform or how to have some sort of pressure release valve to get out of this, then you can suggest something like that. Basically, is that if we're in a situation where we're going all the time on consensus, on agreement, on collaboration, then really what we should be doing is saying that if there is a problem in the future, there's something we haven't covered in the mediation or as a mediator in the parties, let's get together and talk about it again.
All right. Yemi, I think we are just about to finish this. I mean, we are running short of time.
Yep.
So we just open the floor for quick questions. If anybody want to have ask some questions, the panelists would be happy to take it up. And before that, there is one interesting observation, Anil, just what we were discussing about the challenges and all, where it is this observation, it says that we have to think from a worst case scenario. A third-party state may be providing its full enforcement machinery, but what if the agreement was corrupted by mistake or fraud or undue influence? There has to be an escape mechanism for the wronged party. So, what do you?
Yeah, I think that's provided for in the enforcement mechanism, and why it would be allowed and not allowed as well. So I think the convention in that sense might be helpful for that. All right. Otherwise, you know what? Remember, we said that this is a settlement agreement, and parties agreed to it. If there's a question of fraud and so on, you take them to task. So say for example in Singapore, it's an agreement, and if I have a problem with it being a fraud or whatever, I would take out an originating summons. It's called an originating summons in court, and have the court decide whether or not this contract is valid, and whether or not it becomes null and void. Right? So the part about null and void is covered in the convention, but otherwise I think it's something that you want to take to court and have the court decide, because you're talking about the party that's aggrieved from it. So it would not be the party that wants to enforce it. The party that wants to enforce it is the one party that's not aggrieved by it, and then the enforcement would be through the convention. But the aggrieved party, I think your recourse is like any other contract. You're alleging that this contract should be there's fraud and all of that. So it's a matter of taking it to court as opposed to going under the convention.
I think that's the main issue. You see, as I was saying that we are talking here of an agreement, and then trying to enforce it. That's, I think, is the real crux of the issue of enforcement of the mediated settlement agreement in majority of the jurisdiction, I would say. Even in India also, we if something of this is coming into play, then we need to file a suit for enforcing that particular, and it takes a lot of time to get that suit cleared out. Though it's on a mediated settlement, though the parties are still said to be in agreement with each other, but then it's a suit. So I think that is the main issue, which to a certain extent could have been covered up by the convention, though the convention says that it has to be enforced as expeditiously as possible, and probably many of the jurisdictions would be taking that into consideration, but it is still a far cry till the time the various signatories jurisdictions, who have the first signatories, comes out with a proper law or regulations to implement the convention as such.
Shola Ademomiri.
Yeah.
Shola Ademomiri, want to say a few words on Mrs. Cole? They're both mediators from Nigeria, yes?
Yep.
What I just want to add, of course, is what we've all been hearing, that the critical thing in mediation, and which would really take mediation very far, both nationally and internationally, is enforcement. I think one of the problems we still have with mediation, at least in Nigeria, is enforcement, because people expect they've been through a long mediation and they expect that once parties have agreed, it should be enforced. Now you have courts before you are able to enforce. I don't see a reason why, after a mediation agreement is signed by both parties, you have a situation where maybe after 30 days you're allowed to challenge it. And if you do not challenge it after 30 days, it just becomes an in-chambers matter. It's not something that has to go to court, filing process. It becomes an in-chambers matter. And the court in chambers just approves it for enforcement without the need for having to go through court. You have 30 days to say there was fraud, there was mistake, there was misrepresentation. It can't be left open-ended forever before you can have the chance to come and say you want to change this. And after that, it just becomes an in-chambers matter, and it goes through the regular enforcement process in the different nationalities. In fact, it could be the same thing for international. After 30 days, wherever you want to enforce, you go to the national court. The national court looks at there has been no objection where it was made for 30 days, and it's enforced. I think once people know that the enforcement mechanism for mediation is superb, most people will not even want to go through arbitration, litigation, they'll go for mediation. That's my little two-penny contribution. Thank you.
Thank you, Mrs. Shola. And Mrs. Roberts, want to say anything?
Thank you very much for the opportunity, Dr. Agbelusi. I just want to refer to the bill we have before the National Assembly on the repeal and reenactment of the Arbitration and Conciliation Act, which we have changed to Arbitration and Mediation Act when the Singapore Convention opened for signature. And Nigeria was one of the very first countries to sign that convention. Now, we have defined court in that bill as court in chambers, so that we don't have, which addresses the concern just raised by Shola Adegbomire now. So when that bill is passed into law, believe me, it will revolutionize the practice of arbitration and mediation in Nigeria. We're looking forward to it, and it would probably have been passed by now, but for the fact that the COVID-19 happened and there is slow progress in the passing or legislative work of the National Assembly, but we are hoping that that law will be passed this year. Thank you very much, and a very good panel. I enjoyed every bit of it, and I want to thank you all for the knowledge shared.
Thank you very much. Yes, ma'am. Amir?
Yeah, I think I don't think we have any further questions except one another observation to what Anil was just mentioning about the court process and challenging. What it says that, if the convention provides what becomes a statutory process of enforcement, is it possible to challenge by way of usual contractual means?
That's interesting. I suppose, like I said, okay, well, what happens is this. So the party that succeeded would want to enforce it, right? So if he's taken out enforcement proceedings, like in Singapore under the Singapore Convention of Mediation Act 2020, which annexes the convention, then the aggrieved parties' only recourse would be looking at all of the elements that allows him to challenge it. In the Act is Section 4, Section 5, Section 7. In the Convention is Article 5. And look at those, and he may not have any other avenues. Now, if, however, the aggrieved party started off first, right, I agree with the lady who mentioned that it's an in-chambers matter. So what I could do is this. I could take out an application to try and set it as say that this agreement is not enforceable, and go through a process what we call summary judgment proceedings. That, just based on affidavits and submissions made, we are asking the court to decide whether or not this contract is valid, right? So it could be an in-chambers matter. So I suppose it depends on which party jumps first, whether the one that wants to enforce under the convention or the one that's aggrieved and wants to challenge it, the agreement per se. So it depends on which party goes first.
Tony, would you like to add or have your views on this?
Yeah, I think from Vietnamese law perspective, we think that there's no exclusion between the court and the mediation way of enforcing a mediated settlement agreement. So it's unlike arbitration. So you can go through the normal court proceeding. And if you have a problem with the contract provisions that you want to fix it, like, for example, the nudity or invalidity of any part of the contract, you can still apply to the court in the normal proceeding. You don't have to choose between either with the enforcement under the Singapore Convention. Vietnam is not part of the Singapore Convention, but if I assume that Vietnam is a member of the member state of the convention, and I don't think that we would have that problem, because you will go to the court anyway, and you will get your application to the court, and the court will treat the issue with not like Singapore. We will have the normal hearing with to look at the all the reasons whether or not it should be or it should not be enforced, and the court will decide with the panel of the judges.
All right. Adiemi, would like to have the closing remarks on this?
Okay. Well, I always say this everywhere. Commercial matters have no place in courts. And so when parties have chosen a process that gives speed, economy, finality, and maintenance of relationship in choosing mediation as a dispute resolution process, I think we should avoid going back to litigation again. I'll just stop there.
Well, I think we have just about to take up the last question if we have. Otherwise, I'll just wrap this session. And maybe again, just a follow-up to what Anil, you were just mentioning. It says, but the court may not have jurisdiction if it was an international matter. So what to do in that case?
Again, the seats.
No, that's quite simple. I mean, the jurisdiction of the court. I mean, if you take Singapore, for example, the rules of court provide that as long as you can serve your documents on the parties concerned, you can take jurisdiction, right? You also have the Singapore International Commercial Courts in Singapore, where more international matters are dealt with. So it depends, whether if the party is a Singaporean party and brings the matter and shows there's some form of connection to Singapore, they can commence it. So just because the word is international doesn't necessarily mean that the court doesn't have jurisdiction. The court's jurisdiction is in Singapore is the Supreme Court Adjudicature Act and the rules of court that provides the jurisdiction for that. So I think the word international itself doesn't really take it out of the parameters of court systems.
Thank you, Anil. Adiemi, do you want to just share the result of the poll, the last one especially?
Yes. We have 81%.
Yep.
Who, do you think there's an uptake in the use of mediation as a dispute resolution process? Yes, 81%, and that's 8 out of 10 agree that there is an uptake in the use of mediation. And enforcement, do you think the Singapore Convention will solve the problem of the enforcement of international mediation settlement agreements? 5 out of 10 agree, 1 no, and about 4 not sure. Early days.
Yeah.
If I Samir, if I just may just say one point, you must also appreciate, right? It's no longer alternate dispute resolution.
It's appropriate.
It's appropriate dispute resolution. So it's what is most appropriate under the circumstances, either the consensual approach or the adjudicative approach. So this thing about just because of the convention, people are more keen on mediation may not necessarily be the case. If people go back to the basis, and in fact, COVID-19 has brought about this thing that I've been speaking about it for several years now, about collaborative contracting and appropriate dispute resolution. And there are mechanisms in place that we can come out of this far more collaboratively, as opposed to being adjudicative and challenging, right? A lot of people have said that coming out of the COVID-19, we're going to see far more disputes. I don't agree. There are going to be far more issues, but people want to settle those issues without having to go to arbitration or going to trial. So herein lies the perfect opportunity to attempt mediation. Don't talk about the Singapore Convention. You don't have to go down that path, because if you settle, you never have to worry about enforcement.
Exactly.
Yeah?
Exactly.
In fact, I just agree with you, Anil. What we have seen in my experience in India, especially after the COVID-19 things, the landlord-tenant issues or many other issues, people have started having a different kind of mentality, as you just correctly said. They're trying to, resolve the issues rather than fight it out.
Yes.
Nobody wants to fight right now because they don't have that much time. They don't want to spend unnecessarily on, issues in court. So everybody, people themselves have taken up this kind of a mentality, vision, a thinking. There's a drastic change in the thinking of people because of this to, try to resolve it out, as you correctly said, in a collaborative manner. And to see that there's much less hassles and disparities between the parties on the issues. So I thank you all, the participants, especially for taking out time to attend this webinar, and thank you all the panel members for giving your valuable time and of course your views on the different issues on the convention. And thank you, Ariemi, for arranging this. And we look forward to having much more and similar discussions, debates on other burning issues. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.